Okay. Yeah.
Yes.
Hi, Antonio. And yeah, so just have one little question. So your team is composed by 3 persons, correct? And you are the coach.
No, I'm the only one
No,
presenting
you're
today.
D2. No, we cannot hear you because you are muted.
Can you hear me now?
Yeah.
Yes.
Excellent.
Are you Antonio or not?
I'm sorry?
You are not Antonio.
No, I am Antonio.
You are Antonio. Oh, you sound Italian the way you pronounce it.
Sono italiano.
Yeah, I thought so. Anch'io.
Ah,
All right.
piacere.
Nice to meet you.
But-
So Antonio, I just have to make one thing sure in your team. So I understand that your team is composed by 3 persons. So the fact that you have the badge oralist means that you are bleeding today. So that makes things easier for me because I had to make sure that the 2 oralists that have been bleeding yesterday, not both of them will be bleeding today. So the fact that you are one of the oralists automatically excludes that both of them can be the other 2 because you only have another slot. So I don't, you're making things easier.
My coach, David Cameron, he's in the lobby waiting. I don't know if you could see the notification.
Yes, I now see him and I admit him. But hi, David.
Good morning.
Hi, in the good old days, we had the opportunity to see each other in person, now only virtually.
Now, how do I turn? Oh, there we go.
Yeah.
Where you are?
Hey, nice to see you.
Good morning. Good morning.
Hi
Hello.
there.
Hello.
Yeah.
Good to see you.
Okay, so
Hello.
I was just making sure that because I know that the team is composed by 3 students, so I just wanted to be sure as to the students who are bleeding today, and Antonio can explain the whole matter to you. It's these formal things that I'm obliged to do to be sure that everybody complies with the rules and that I do my job properly. It's a kind of bureaucracy, but at least it allows us to make sure that we are playing by the rules. And yeah, good. Okay, so we are actually ahead of time until the other the others arrive. So yeah.
But it's a long time ago, David.
It has been a long time.
That I met you in person.
Exactly.
I think on one of the EATLP meetings.
Right. It's unfortunate. I was hoping that we'd finally be able to be back and live in this year.
But I presume at some point they had to make a decision, and I presume for safety reasons they.
It was risky also because of the fact that it would be very bad to have some people coming in and some others not being admitted. Then we were also wondering as to what could have been the reaction by the universities, because at some moment some universities were not allowed to send their teams traveling. So it was quite a difficult decision. Of course, it's not the same, but we have to take it for what it is. So it's and meanwhile, I see that we have also the applicant team. So I assume that you are the oralists for Team E, and I can actually see that one of you has E3 and the other one is E1. So that's very clearly visible, at least as far as I can tell. So then I see that we have the oralist. We're just missing one oralist, aren't we?
No?
No, from the other team.
It's just me.
It's just you. Okay, right. Because I thought that I thought that the communication had been that there would be another oralist with you. So we have been exchanging emails, and it's actually not with me, but with the co-arbitrator. I assume you are the coach.
Yes.
Okay, so it's just going to be you. Okay, because I thought I had exchanged emails with my co-arbitrator to say that we would have been having one oralist pleading twice. At the end of the day, both solutions are not exactly as they would be because there would be one person pleading twice. Okay, I think it's not a problem. We can handle it this way, and in fact, it's a team composed by 3 persons. Okay, so let's prepare. I think you have already been informed about the fact that there will be 30 minutes available for pleading, and there will be then the possibility for rebuttal, which is for Team E to decide if Team E goes for rebuttal, then Team D can go for sub-rebuttal. The overall timing of the rebuttal is 5 minutes and 5 minutes for the sub-rebuttal. I will be intervening to the extent that it's needed to enforce timing, and that means that during the pleading I will send you a chat warning 5 minutes before the time elapses, and there will be an oral intervention 1 minute before time's up. And when time's up, please just complete the sentence. As for the rebuttal and sur-rebuttal, because it's only 5 minutes, I will only intervene orally when 1 minute is left. And then we have a session with the so-called Q&A, where the judges will make sure that each oralist can be answering specific questions connected with the case, but also starting from the case. All of this is clearly important for the judges to have a clear way of assessing your technical knowledge. Please also understand that they will have to assess your ingenuity among others, and therefore when you engage in rebuttal and sur-rebuttal, we warmly advise always to make a reply to the specific points that have been indicated during the pleading, and this is in order to avoid that somebody prepares a rebuttal or sur-rebuttal. Of course, if he or she wants to do that, that's not a problem, but the judges will have to evaluate the ingenuity. So we stress it, we bring it to your attention. I think I need not to say, I don't need to say anything else apart from introducing you to the court. And today we have a court chaired by Professor Meussen, and also including as members Professor Van der Kerke and Professor Nogueira. I hand over to Professor Leusner, to the chair. I will be liaising also with the other courtroom, and for this reason I will be without video, but I will be always...
We still need the letters. We still need the letters.
Oh, yes.
Identification of the...
I said when the two oralists from Team E joined, so that, how can I say now which one is which? You both have passes. Okay, so one is E1 and the other one is E3.
E3, yeah.
But it's difficult for me to say which one is which because they are dressed in a similar way.
Yeah, I can read E1 and E3.
I can read. Yeah. And they're not sitting in the same room.
This is occupied.
And that for JAL, for defendants team is only one oralist, D2.
And it must be D2 because it's the only one. So,
no, we're good.
Yeah.
Aren't they sitting in the same room? No?
We
are, I think.
They are? Are you?
Yes.
You are in the same room?
Yes.
But we don't have echo. Strange. Okay, we have echo definitely if you open up both your microphones. Anyway, yeah. But you are maybe so coordinated that you avoid this torture. Okay, good. Okay, I hand over now to Professor Meussen. I asked Judge Nogueira if he has got all the letters and numbers right. Thumbs up. Okay. Right, we are ready to start.
So, ladies and gentlemen, I welcome you to this court session of the Waterland Tax Court in a tax case concerning the Gulf Star Company against the Waterland tax authorities. And to start with, I would like to give the floor to the applicant's team to hold their initial pleading. So the floor is yours.
Honorable Chairman, Honorable Court, thank you very much. Mr. Buggy is a professional, hard-working golf player, and the Star Golf Company, hereafter also referred to as SGC or company, supports him on every step of his career. Mr. Buggy is only special in that he works exclusively for the company and is paid for it. Of course, Mr. Buggy's income was taxed in Waterland. However, the Waterland tax authorities have been lately announced that they would like to raise a larger tax claim and have now sent a tax assessment to the SGC. Against this unjustified demand, and especially the insinuation that the SGC would be abusive, my colleague and I will represent and defend the company. I would like to start summarizing our opinion regarding the taxation situation. We are convinced that only Article 7, paragraph 1 DTC can be applicable, so that the income is treated as business profits. After all, the company is a company and earns income as such. Article 7, paragraph 1 DTC assigns the right of taxation to the residency states, thus the Temporary Republic, because no permanent establishment exists. However, before we prove that the right of taxation therefore lies in the Temporary Republic, we must reject the more specific provisions that might be considered. These are Articles 17 and 12. We will argue in the following why these provisions are too specific and therefore not applicable. After we have concluded that, and only Article 7 DTC remains, we will prove that the right of taxation lies in the Temporary Republic. I will now explain why taxation via Article 17 DTC is not possible in our case. Because the company is not a sports person, there is no second paragraph in the DTC, and the idea of second paragraph cannot simply be transferred like that either, especially because the Star Golf Company is not abusive. So first, the Star Golf Company is not a sports person. That the recipient is a sports person would be absolutely necessary for the application of Article 17 DTC. And a sports person is at least characterized by the fact that he or she engages in sporting activities. A company as such cannot do that. Something else makes no sense, just as no table, no apple, and not even a pair of trainers could perform sporting activities. Furthermore, it is not enough that Mr. Buggy is a sports person. This does not meet the requirements for the personal activity of the sports person, which is also absolutely required by the wording of the DTC. Moreover, the Star Golf Company is not a one-person company. A one-person company consists of only one single shareholder and one single director without any staff or management. In our case, there are at least 3 different directors and shareholders, so we don't have a one-person company. An application of Article 17 DTC seems unconvincing at all, because the wording of Double Taxation Convention does provide for taxation of companies. This is shown by the fact that we don't have a second paragraph in the DTC, unlike in the Model Convention. And since there is no second paragraph in Article 17 DTC, it cannot serve as a legal basis. And in this specific case, one cannot resort to the dynamic approach to change the wording of the agreement, precisely because the parties have decided not to change Article 17. The dynamic approach is intended to update outdated provisions, to address circumstances that the contracting states at the time could not have foreseen. But the last update of the Double Taxation Convention took place in 2018, so the treaty is by no means outdated, and therefore does not need to be interpreted dynamically. So we have no paragraph 2, and the OECD Model Convention is not binding. In the search for a legal basis for taxation, one might come across the OECD Model Commentary. This is not binding either, as it says itself in instruction number 29, but at least it links to something binding, namely the wording of the agreement. But as Article 32 of the Vienna Convention states, it only must be used if the wording of the tax treaty is unclear. That is not the case here. The wording of Article 17 is absolutely clear, as has already been shown. For this reason, recourse to the OECD commentary is not necessary in our case. So in our opinion, the look-through approach or other similar constructions are not applicable in general in our DTC. If the Honorable Court does not wish to follow us on this point, I will explain why the look-through approach cannot be applied specifically in our case, simply because the style of company is not abusive. There are two possibilities in the commentary which a tax authority could try. One is number 8 from the model commentary in Article 17, and the other is number 11.3. The look-through according to number 8 requires a special rule in domestic law in order to apply the principal purpose test to Article 17. There needs to be provision that specifically allows for the crackdown on efforts. But there is no such provision in Waterland's domestic law. Moreover, by applying the look-through, Mr. Buggy would end up being taxed and not the startup company to whom the tax assessment actually went. That's why the look-through cannot be applied in this case. Only number 11.3 remains, which leads to the domestic law. This includes both a national anti-abusive rule and the Double Taxation Convention. So our relevant test is the principal purpose test from Article 29 DTC or the sole or main purpose test from the domestic law. It depends on which way you want to go. The sole or main purpose test, I will examine the PPT because it has the lower requirements. The sole or main purpose test is tested in the same way and only has higher requirements for the purpose. First, a real benefit. Second, requirements for a principal purpose in obtaining this benefit. And third, the fact that no counter evidence exists are necessary for this. The sole or main purpose test is tested in the same way and only has higher requirements for the purpose. If the PPT doesn't succeed, the sole or main purpose test a fortiori does not. During the application of PPT, I will introduce criteria from the model commentary. It is not contradictory that I am now interpreting the commentary. Unlike Article 17, the wording of Article 29 DTC is not clear. So here we need indications of the commentary to be able to analyze the company reasonably. There is already no benefit in our case within the DTC. A benefit, according to the model commentary on Article 29 and 175, requires a limitation of taxation in the source state through the convention. The benefits of the domestic law are not included, but only through the DTC. So in our case, the taxation of dividends could not be assumed as a benefit. At least one could assume a benefit at the 2.5%. Even if someone wants to let this suffice, requirements are not fulfilled. There must be, according to all relevant facts and circumstances, a principal purpose in obtaining the benefit. This must be a capital purpose. One cannot simply infer a purpose from an advantage, as the model commentary itself states. There are a few examples in the commentary which criteria can be derived. The most important indications of an abusive tax management are: first, a significantly lower tax due to the arrangement; second, the company cannot make its own decisions; and third, it has no economic value. So first, the tax advantage is just 2.5% of the income of only one tournament out of 6 that take place per year. Moreover, Mr. Buggy will not earn the prize money every year because no one can rely on winning. And then there are the earnings of the other 3 professional golfers. This is, in summary, extremely small amount for the company. Definitely not the significantly lower tax that would be an indication of an abuse. and definitely not the big tax advantage for which someone was set up a company. Mr. Baggy did not only give up shareholdings, but all directors are paid directors on top. So the incorporation of a company only for this tax advantage would be a losing business. Moreover, the company was incorporated in the birthplace and then residence of the founder, Mr. Baggy, who at least one of the other directors, the executive director, Mrs. Fixit, was and still is resident. Second, the company acts in a self-determined manner. The most important decisions are decided in the directors' conference, which takes place 6 times a year. Everything else is decided by Mrs. Fixit as the executive director. The company can therefore make its own decisions and is not dependent on an outsider. If someone wants to claim that Mr. Baggy could make a decision with his business shares, this is not true. He can only confirm tournaments or contracts planned by Mrs. Fixit. He has no right of initiative to oppose himself. Thus, he is dependent on what Mrs. Fixit prepared. So there's even a balance of power within the company, like yin and yang. And finally, the company has also high economic value because the number of managed golfers has quadrupled since incorporation. So the company receives first a 10% remuneration from the other golfers' income, and second, another 10% commission from the investment returns. So it's a business model based on working with the golfers in the long term to maximize profit. This concept offers ability to both the clients and the company, so the economic value should not be underestimated either. Furthermore, liability risks are secured through the incorporation of the company. So the requirements for an abusive principal purpose aren't fulfilled. But even if they were, we as the taxpayer could provide the counter evidence. If the tax treaty is interpreted correctly, Article 7, paragraph 1 DTC must be applied. The states choose intentionally to leave it at the one and only paragraph in Article 17 DTC. The look-through approach cannot be more than an exception. So the SUC cannot circumvent the tax prevention that the states neither wanted nor included. That is why the look-through approach cannot be applied, specifically in our case. Because the benefit is already questionable, we have no abusive principal purpose, and the counter evidence is fulfilled. Honorable Chairman, Honorable Court, dear ladies and gentlemen, thank you for your attention. I now hand the floor to my colleague who will further explain why taxation in Warland is out of question and the right to tax lies in Czech Republic via Article 7, paragraph 1 DTC. Then it will also become apparent that the only anchor of the tax authority is the unrealistic insinuation of an ominous abuse. So we will finally prove that a tax assessment is not legally.
Okay, thank you.
Thank you very much. As my colleague has just explained, Article 17 DTC is not applicable. Honorable Court, all considerations and clever ideas do not change the fact that the Star Golf Company is not a sports person, but a company. And what does this conclusion mean? Exactly, that the entire income is taxable via Article 7, paragraph 1 DTC. And therefore, our request is also that the income of the tournament is taxable via Article 7, paragraph 1 DTC in the Championship Republic. I will prove this in the following, but before that, I will explain why taxation cannot take place via Article 12 DTC. Considering Article 12, payments that are made for the use of personality rights, such as for image rights or the right of one spoken word, do not fall under Article 12 DTC. This is clearly because they are not mentioned in the clothing enumeration of Article 12, Paragraph 3 DTC, which defines royalties. So it cannot, all of a sudden, just be included. If our states actually wanted to include personality rights, they could just have added them like other countries, for instance, the United States. This is also the reason why one cannot refer to judgments from the United States, because there the tax treaties explicitly allow personal rights to also fall under Article 12 DTC. Even if one were to argue that such payments were made for the use of a trademark, this is not conclusive. There is no legal definition of a trademark in the OECD commentary. For this reason, one must make a reference to the national law. In the national law, a trademark is a mark distinguished for goods or services, for example. The Oxford Dictionary says that a mark is a written or printed symbol used for a sign for something, for example, that owns the sign. So this means a person is not a written or printed symbol and therefore cannot be a trademark. Further, even if someone wanted to argue that the scope of applicability was opened, a taxation of 10% cannot be exceeded. This is because the Stargolf company is the beneficial owner of Mr. Buggy's image rights. And I'm going to show you in the following why. The beneficial owner is characterized by being the recipient and having control over all income. In addition, some say that it must not be a conduit company. A conduit company is a company established in connection with a tax avoidance operation. As the concept of the beneficial ownership is also an abuse regulation, parallels can be drawn with the principal purpose test. As the principal purpose test is not relevant here, the same must apply to the beneficial ownership. First of all, the Stargolf company is of course the recipient of the income. They also have all the power regarding the disposition in the interest of the firm. They can use the earnings without having to give them to someone. But the most important point is that there is no contractual or legal obligation as what happens to the money. The conclusion is that the recipient must be the beneficial owner. In this case, the Stargolf company is the recipient of the entire income. So, the Stargolf company is the beneficial owner. And as already proven by the failed principal purpose test, the Stargolf company is not abusive and therefore cannot be a conduit company if someone wanted to say that. Furthermore, they are not a conduit company simply because they have an actual presence in the Championship Republic through Mrs. Fixit as the only executive director of the company. As the same tax treaty was concluded between all three states, one cannot conclude that this is a conduit company. If the
perhaps one element of order for the defendant team, perhaps it's good to put out your microphone because we can hear the sounds all the time. Okay, carry on.
As the defendant's representatives want to assume that the company was only founded in order to obtain tax relief, this is not correct. This would ignore the fact that in principle, everyone is free to establish a company. Rather, the purpose of setting up a contribute liability risks. It must also be considered that Mr. Buggy founded the company in order not to take any risks and therefore does not want to be the beneficial owner of his image rights. Furthermore, it would be wrong to conclude from the fact that 80% of the business shares are held by Mr. Buggy that the Stargolf company is not the beneficial owner. In fact, is Mrs. Fixit the only executive director in the company? This is not Mr. Buggy. She alone can draft the contracts for Mr. Buggy's image rights. These are voted on in director meetings, but there is no indication that any amendments will be made. Rather, they trust Mrs. Fixit and follow her suggestions. Mr. Buggy has no such right of initiative. For this reason, the Stargolf company is the beneficial owner. All in all, the Stargolf company could therefore not be taxed more than at least 10%, even if the Honorable Court like to assume that Article 12 DTC is applicable. Honorable Court, up to now, it has only been a question of excluding more specific provisions, as these are obviously not present in our case. Now, I would like to pay special attention to Article 7 DTC, as this is the only article through which taxation can take place. However, a solution via Article 7, Paragraph 1 DTC is the only relevant way in our case. Article 7 regulates the taxation of business profits. All the pretextual tax bases that are supposed to be lex specialis are just too special and therefore not applicable. Namely, since the Stargolf company does not maintain a permanent establishment in the Republic of Waterland, all income is taxable via Article 7, Paragraph 1 DTC in the Championship Republic. And why can no permanent establishment be accepted? Exactly, because none of the conditions are met. Article 5, Paragraph 1 DTC states that a permanent establishment is a fixed place of business through which the business of an enterprise is wholly or partly carried on. The listed examples in Article 5, Paragraph 2 DTC do not extend the scope of application, but only have a clarifying effect. For this reason, I will now go through the requirements of Article 5, Paragraph 1 DTC. First, one would need a fixed place. This refers to a temporal and physical fixity. This is not the case here due to the short duration of Mr. Buggy's days. Furthermore, he has no room or office in the Republic of Waterland. As there is no fixed place, no business activity can be carried out. This means that the requirements of Article 5, Paragraph 1 DTC are not met, so there is no permanent establishment in the Republic of Waterland. This means that taxation via Article 7, Paragraph 1 DTC is the only relevant way for the entire income of the tournament. Therefore, the income is taxable via Article 7, Paragraph 1 DTC in the Championship Republic. Even if one would try to reconsider this position by using the so-called painter example introduced in the OECD commentary, this would not lead to sufficient permanent degree in our case. In this example, the painter worked for 3 days a week for 2 years in the building of his main client. Neither the faraway golf club, the Star Golf Company's main client, since there are at least 5 other major tournaments its golfers participate in, nor is Mr. Buggy playing recurrent every week in the Republic of Waterland. Furthermore, to get a combined stay of 2 years, Mr. Buggy has to participate 104 times in this tournament. And although sport is supposed to keep us young and healthy, Honored Court, I dare to doubt this prediction. Thus, taking all of these points into account, there is still not a degree of permanence that would be against the wording of the paragraph. Therefore, no permanent establishment can be assumed. Without a permanent establishment, Article 7, Paragraph 1 DTC refer the right of taxation to the Championship Republic, where taxation has already taken place. Honorable Court, if the counsel of the defendant now want to write the club of Article 29, I would like to remember you that we have already clearly proven that there is no case of abuse by the company. My colleague has just presented the 3 categories one which can determine that there is no abuse. I would like to summarize this again briefly. First, we do not have a significantly lower taxation due to the arrangement. As already stated, the difference is only 2.5%. Secondly, the Star Golf Company can make its own decisions, as Mrs. Fixit is the only executive director in the company and the only person who can draft the contracts. Thirdly, the Star Golf Company has an economic value because they are managing Mr. Buggy and 3 other professional golfers. Not every company has to aim to be a big global company with 100 of employees. This is not proof of abuse. Therefore, the Star Golf Company is not abusive. One could argue about the legal consequence of Article 29 DTC, but the wording and the purpose of a tax treaty agreement clearly dictates the consequence. Article 29 states, a benefit shall not be granted if the benefit was one of the principal purposes. The imputed benefit is not Article 23b DTC. According to the facts, Article 23b is applied. This means that the tax authorities can demand 15% tax, for example, but then the Star Golf Company could recover the 12.5% already paid in the Championship Republic if this would be credited. As the imputed benefit is not Article 23b, it cannot deny it via Article 29 DTC. This would not be contrary with the purpose of the tax treaty agreement. It would inevitably lead to double taxation. However, withdrawal of the entire treaty protection would be contrary to the principle of proportionality. To conclude, Honorable Court, please let sense and justice prevail. It is only understandable and natural that the tax authorities want as big a piece of the pie as possible. But there are limits. There is no basis for taxation in the Republic of Waterland. Even with a dynamic approach, the wording of the paragraph cannot be exceeded. Therefore, we ask to leave it at the already performed detailed taxation via Article 7, Paragraph 1 DTC in the Championship Republic. Honorable Court, thank you for your attention.
Okay, thank you very much. Then I give the floor to the defendant's team, to Team D, and to oralist D2.
Preliminary issue. Can everybody hear me loud and clear? Excellent. All right. Honorable Chief Justice, Your Excellencies, and may it please the court. I am D2 and I represent the defendant, which is the Republic of Waterland Revenue Service. Your Honors, the defendant is asserting that because Mr. Buggy purposely availed himself to the Republic of Waterland and earned significant amounts of income, he is therefore liable for all taxes levied. For this assertion, I am going to take you through the following topics of our pleading. Firstly, I will acknowledge how this court is bound by the Vienna Conventions in its interpretation of tax treaties. Secondly, the defendant will present to you the 6 undisputed facts that support our case. And then, Your Honors, the government is going to present to you the following 3 main arguments. Firstly, all amounts are taxable in the Republic of Waterland because they were earned by a sports person via his personal activities. The second main argument, the applicant, Star Golf, is not the beneficial owner of the items of income and therefore does not qualify for any treaty relief whatsoever. The third and final argument is that Article 29 would anyhow deny any treaty benefits to the applicant because they committed abuse violations by incorporating themselves in Championship Republic. While addressing my arguments, I will be countering my opposing counsel's argument where relevant. In sum, Your Honors, I have full faith and confidence that this court will be able to hold this applicant liable for all taxes levied. And now the government would like to first present our Vienna Convention acknowledgement. The government fully acknowledges that we are bound by the Vienna Convention in our interpretation of tax treaties. Section 3 of Article 31 of the Vienna Convention specifically holds that, quote, any treaty shall be interpreted in good faith and in accordance to the ordinary meaning to be given to the terms of the treaty in their context and in light of its objective and purpose. It goes further onward to explain in the event that there is supplementary materials, then such supplementary materials are allowed to be used in interpreting tax treaties. Additionally, Your Honors, the 2018 protocol to the Vienna Convention allows parties to use the commentaries in their interpretation treaties. This is relevant for our purposes because we, the government, and this court are allowed to use the OECD commentaries to their fullest in interpreting the tax treaty between Championship Republic and the Republic of Waterland. And now the government would like to present the 6 undisputed facts that support our case. Firstly, Mr. Buggy came to the Republic of Waterland and participated not virtually via Zoom or Microsoft Teams, but in person in the Fairway Golf Tournament. While at the Fairway Golf Tournament, Mr. Buggy earned the following items of income: 450,000 euros for imagery rights income, 500,000 euros for the winning, so the prize winnings, and then 250,000 euros for sponsorship payments. The third relevant fact is, despite Star Golf's leadership and personal assistance in the Kingdom of Greens and its significant connection to the Kingdom of Greens, it is incorporated in Championship Republic. The fourth relevant fact is that Championship Republic is home to the lowest tax rate in all of the jurisdictions provided for, with a flat 12.5% regardless of the type of item of income. The fifth relevant fact is that the domestic law of all the countries provides for a general anti-avoidance rule similar to the principal purpose test. But for the initial test being that the tax benefit must be the sole or main purpose of any arrangement. The sixth and final relevant fact is that all the countries, Kingdom of Greens, Championship Republic, and the Republic of Waterland, we are all in agreement as to what a trademark means. And it means a mark used by a person in relations to goods or services for the purpose of distinguishing the goods or service in relation to which the mark is used from the same kind of good or services. The government has just concluded our 6 undisputable facts, and now the government would like to present our arguments, beginning with argument number 1, and it is again, all amounts are taxable in the Republic of Waterland because they were earned by a sports person via his personal activities. Your Honors, for this main argument, there are 3 sub-arguments that are supporting it. The 3 sub-arguments are as followed. Firstly, Article 17, Paragraph 1, permits a sports person who earns income via personal activities to be taxed in the state in which the personal activities were performed in. Secondly, the facts that the tax treaty does not contain Article 17, Paragraph 2, along with the fact that Stargolf itself is not a sports person, are simply irrelevant. The third sub-argument is that even if Article 17 is not applicable, then at the very minimum, the government can successfully tax the 450,000 imagery income as a royalty payment under Article 12. And now the government would like to present sub-argument 1, and it is again that Article 17, Paragraph 1, permits a sports person who earns income via personal activities to be taxed in the state in which the personal activities were performed. There is no dispute here that Mr. Buggy is indeed a sports person, because golfers are included as being sports person. And because Mr. Buggy is a golfer, then we can conclude Mr. Buggy is indeed a sports person. But now it is time to show what right does the government have in terms of taxing the items of income. The right the government has is that we can rely on the OECD commentaries along with secondary material, beginning with the 450,000 imagery income. Article 17, Paragraph 9.5 specifically holds that it is frequent for entertainers and sports persons, such as Mr. Buggy in our situation, to derive directly or indirectly a substantial part of their income in the form of payments for the use of or for the right to use their image rights, such as the use of their name, signature, or personal image. With this rule as the background, we look to Mr. Buggy's situation, and we can successfully conclude that just how the commentaries provide for somebody being paid for the use of their name, signature, and image, well, so too was Mr. Buggy paid for his name and his image, because that was the core trait used in the in-person advertising and in-person interviews for the Fairway Golf Tournament. And as a consequence of his actions, the government can successfully tax such item of income. The next item of income is the 500,000 prize winnings. It is true. The tax treaty is silent to specifically classifying prize winnings as one's item of income. But let's take a moment here, Your Honors. Just because an item is not included in one's item of income, does that mean it should be excluded from taxation? The answer is simply no. What we, the government, can rely on are the taxing authorities of other countries. By looking at the taxing authorities of the United States, Japan, Turkey, and Germany, all countries acknowledge that prize winnings, let alone for a payment of 500,000 euros, are certainly included in one's individual item of income. Therefore, we, the government, can rely on such globally agreed upon customs. Why should Mr. Buggy be the exception to this rule? He should not be. And therefore, as a consequence, the government can successfully tax such item of income. And now we draw your attention to the 250,000 sponsorship payments. Article 17, paragraph 9.0 specifically holds that Article 17 will apply to advertising or sponsorship income, which has a close connection with the performance in a given state, and the commentaries provide us with a clear example, such as payments made to a tennis player for wearing a sponsor's logo, trademark, or trade name on his tennis shirt during a match. With this rule as the background, the threshold here is for a player to simply wear their logo, their sponsor's logo, on their t-shirt. Well, Mr. Buggy already met this threshold by wearing the clothing attire of his sponsors, but he didn't just meet this threshold, he surpassed it by using the gear of his sponsors, and as a consequence, the government can also successfully tax the 250,000 sponsorship payments. Now, my opposing counsel mistakenly argues that, quote, Star Golf maintains no permanent establishment in the Republic of Waterland and therefore cannot be taxed under any theory, Your Honors. However, the applicant committed a bit of a disservice because they did not mention to this court the concept of source-based priority taxation. Klaus Vogel holds that the underlying principle of Article 17, paragraph 1, is that states in which are the source of an item of income have the right to lay claim and tax such item of income because that item of income arose in that state. The government has just concluded sub-argument 1 and is now presenting sub-argument 2. And it is, again, the facts that the tax treaty does not contain Article 17, paragraph 2, along with the facts that Star Golf is not a sports person, are irrelevant. These facts are irrelevant for the following 2 reasons. Firstly, in the absence of Article 17, paragraph 2, tax treaties allow the use of domestic anti-abuse laws under paragraph 66 of the commentaries to Article 1. The second, the second reason why these facts are irrelevant is because as a result of paragraph 66 of the commentaries, then the Republic of Waterland's domestic anti-abuse laws allow us, the government, to pierce that corporate veil and tax Mr. Buggy directly. Your Honors, let's take that first reason and first draw your attention to Article 1, paragraph 66, which specifically holds that domestic anti-abuse rules and judicial doctrines may also be used to address transactions and arrangements entered into for the purpose of obtaining treaty benefits in inappropriate circumstances. And therefore, Your Honors, this begs the question, what are or is the inappropriate circumstance that merit the government to activating paragraph 66 of the commentaries to Article 1? The inappropriate situation here was Star Golf's incorporation in Championship Republic. The applicant has not put forward a compelling reason why Star Golf had to be incorporated in Championship Republic. If we look at their leadership as an example, it left Championship Republic. It's in the Kingdom of Greens. If we look to where Miss Dots, arguably the main person upholding Star Golf because of the personal assistance she provides to Mr. Buggy and therefore the leadership, all of the leadership is in the Kingdom of Greens. And it is also quite ironic that Star Golf just had to be incorporated in this jurisdiction with the lowest tax rate. Such incorporation is indicative that they sought to only take advantage of that lowest tax rate. And because abuse is clearly visible here, the Republic of Waterland is allowed for us to use our own domestic anti-abuse rules. The Republic of Waterland's domestic anti-abuse law holds that, quote, the domestic law of all countries provides for a general anti-avoidance rule similar to the principal purpose test, but for the initial test being that the tax benefit must be the sole or main purpose of the arrangement. And therefore, Your Honors, we could simply hold that why else would Stargolf incorporate itself in Championship Republic if not for to take advantage of the lowest tax rate out of all the countries provided for. The government has just concluded sub-argument 2 and is now going to present sub-argument 3, and it is again, even if this court were to hold that Article 17 is not applicable, then at the very minimum, we, the government, can successfully tax the 450,000 imagery income as a royalty payment under Article 12. Before we get to Article 12, we have to get to Article 3 first. Article 3 simply holds that for any terms not defined in the tax treaty, then that term will have the meaning ascribed to it under the laws of a contracting state. So the term that the government is invoking here is indeed a trademark. And it is, again, the all countries agree that a trademark means, quote, a mark used by a person in relations to goods or services for purposes of distinguishing the goods or service in relation to which the mark is used from the same kinds of goods or services. I know that was a lot for all of us, but all this is simply saying is that as long as there is a trait of a person used for commercial purposes, then such trait is indeed a trademark. This type of reasoning is not unknown to the tax world, but rather it's clearly evident and is truly prevalent not only in the commentaries, but in two leading U.S. tax court cases. Beginning with Article 12, it specifically holds that the term royalties, as used in this article, means payments of any kind received as consideration for the use of or for the right to use of any copyright, literary, artistic, or scientific work, and then it gives other examples, but includes a trademark. With the OECD commentaries as a background, it's time to look at the two U.S. leading tax court cases. The first U.S. tax court case is Garcia versus Commissioner. The United States held that payments made to Mr. Garcia for the use of his image qualified as royalty payments. And then in another U.S. tax court case, Goosen versus Commissioner, the court held there that payments made for the simple use of the athlete's name, Your Honors, was sufficient to be deemed those payments as royalties. Taken together, Article 12, along with the U.S. tax court cases, these are saying that a trait of a person, such as their name, their image, or signature, qualifies as a trademark, and such payments made for the use of the trademark qualify as royalty payments. With this rule as the background, we look to Mr. Buggy's situation, and just like in Mr. Garcia's case and Mr. Goosen, he too, for the 450,000 imagery income, was paid that amount for the commercial use of the trait of his name and his person. Hence why he conducted the in-person interviews and his name was promoted throughout the tournament. And as a consequence, the government can successfully tax such an item of income. Your Honors, the government has just concluded argument 1 and is now presenting argument number 2. And it is again The applicant is not the beneficial owner of the items of income, and therefore doesn't even qualify for treaty relief. In determining what beneficial ownership means, we have to look to our colleagues over in Canada across the pond. And there are two leading Canadian tax court cases that assist in this endeavor. The first is Provost Carr versus Her Majesty the Queen. In this tax court case, the Chief Justice held, quote, "In my view, beneficial owner of dividends is the person who receives the dividends for his or her own use of enjoyment and assumes the risk of control of the dividend he or she received." Now, if there was a time for that kind of logic to be questioned or reprimanded and remanded, it came and passed, because in the second Canadian tax court case, Velcro versus Her Majesty the Queen, that kind of logic and reasoning from Provost was reaffirmed word for word. Taken together, this simply means that beneficial ownership means looking at the person who truly received the items of income for their use and enjoyment and assumed the risk of control. This now begs the question, well, what happened to those items of income, the $400,000, the $500,000, and the $250,000 payments? Did Star Golf reinvest such item of income? Did Star Golf commit it to its R&D or put it in its retained earnings and profits? The answer is no, Your Honors. Such items of income were liquidated to the shareholders. But now that begs the question, who are the shareholders? And it is indeed Mr. Buggy is one of them. But the case here is not as if Mr. Buggy is a 5% minority shareholder, or even 10, or even 20, or even 40 or 50. He is the controlling shareholder with a massive 80% equity hold over Star Golf. What this means for beneficial ownership for our purposes is that for every item of income received by Star Golf, he receives 80% of those distributions. And therefore, he received 80% of the $450,000 imagery income, 80% of the $500,000 prize winnings, and 80% of the $250,000 sponsorship payments. He's the true beneficial owner, because by such distributions, they went directly to Mr. Buggy's pockets, not to Star Golf's retained earnings and profits. And therefore, the applicant is not the beneficial owner by any means of those items of income, and as a consequence, doesn't even qualify for any treaty relief. And now the government is presenting our final conclusion, our final argument, and it is that Article 29 would anyhow deny any treaty benefits to the applicant because Star Golf committed abuse violations by incorporating itself in Championship Republic. Your Honors, looking at Article 29, it specifically holds that, notwithstanding the other provisions of this convention, a benefit under this convention shall not be granted in respect of an item of income or capital if it is, and I want to place an emphasis on this following word, if it is reasonable to conclude, having regarded all facts and circumstances, that obtaining the benefit was one of principal purpose of any arrangement or transaction that resulted directly or indirectly in that benefit. Your Honors, we, the government, and this court are allowed a low threshold of a reasonable standard. And with this reasonable standard, we could look at all relevant facts and circumstances. And therefore, it is reasonable to conclude that Star Golf only sought to incorporate itself in Championship Republic because of the lowest tax rate that country provides. This fact, coupled with the fact that all of its leadership left or not all of it, but its main leadership and personal assistance to its leadership left Championship Republic, along with the significant fact that board meetings, the true meetings where leadership decisions are decided, aren't even conducted in the Championship Republic. It's done in the Kingdom of Greens. The applicant mentions that it's insignificant, it being Championship Republic's low tax rates, and that it's only a 2.5% difference. But Your Honors, is it truly insignificant, a 2.5 tax on 500,000 euros worth of income? It is significant, and we can conclude that Article 29 would anyhow deny any treaty benefits to this applicant because they committed abuse violations by incorporating itself in Championship Republic. And now, Your Honors, the government would like to present our conclusion. Honorable Chief Justice, Your Excellencies, the government has presented the following topics of our pleading. We first acknowledged how this court is bound by the Vienna Convention in its interpretation in tax treaties. Secondly, the government took you through 6 undisputed facts that support our case. And then, Your Honors, the government presented to you our 3 main arguments. Firstly, all amounts are taxable in the Republic of Waterland because they were earned by a sports person via his personal activities. Secondly, the applicant is not the beneficial owner of the items of income and therefore does not qualify for any treaty relief whatsoever. Finally, Article 29 would anyhow deny any treaty benefits to the applicant because Star Golf only sought to incorporate itself in Championship Republic and therefore committed abuse violations. In sum, Your Honors, I have full faith and confidence that this court will be able to hold the applicant liable, and I yield my time.
Okay, thank you very much. I have one question addressed to the arbitrator. I see on my screen that there is sitting someone next to E3, or
Yeah, but that's a person.
is that E1?
Yes.
Okay, yeah, so that problem solved.
Yeah, because they said that they were in the same
They
group.
said in the
Remember, I
beginning,
made the jokes
precisely.
about the echo and the fact that they are synchronized.
Okay, right. Then if Team E wants to have a rebuttal, then now I would like to give the floor to Team E for their rebuttal.
Thank you, Honored Court. Unfortunately, the tax authority focused at the wrong reference point. We agree that Mr. Buggy is a sports person, but we are agree that the tax authority can tax Mr. Buggy via Article 17 DTC. I would like to present this in 3 arguments. The tax assessment of the tax authority is not directed at Mr. Buggy.
Just one moment, stop, please. Just one moment, stop. I see that the oralist D2 has difficulties in hearing you.
Okay.
Is that correct? Because, he has the right to hear you properly. I'm sorry if I intervene. Can you please confirm oralist D2, because you have the right to be put in a position in which you can respond to that.
I can hear her, it's just I have to hear her a little bit more. So we're good, we're good.
As long as you say that you have a fair chance to hear, it's okay.
We're doing good, keep up the good work.
Okay. I apologize for interrupting you. As you see, I have blocked the timing. Please continue.
Thank you. I would like to present the 3 arguments why that is not possible to tax Mr. Buggy about Article 17. So first, the tax assessment is not directed at Mr. Buggy, but to the startup company, and we aren't presenting Mr. Buggy but the startup company. Second, if Mr. Buggy would be the taxpayer, we would be in the wrong DTC because our is resident in Kingdom of and Waterland and Temptation is not the recipient of the income, and that is absolutely necessary. Otherwise, no one have to argue about the look-through from number 8 from the commentary. 3 arguments. Made clear that it is not possible to tax Mr. Buggy via Article 17 TTC. Therefore, this taxation is not possible in our case. Thank you for your attention.
I would like to add something. First, I come to the argumentation why the Stargolf company is incorporating the Championship Republic, because there are 3 arguments for it. First, when Mr. Buggy founded the company, he was a resident in the Championship Republic. Second, it is not right that the company is founded in a lower tax country from the 3 states, because we already not know how the taxation is in the Kingdom of Queens, so one cannot make this comparison. And thirdly, Mrs. Fixit is still resident in the Championship Republic, and Mrs. Fixit is the only executive director from the Stargolf company. So, secondly, I would like to say something about the image rights and Article 12 DTC. First of all, I would like to comment to the judgments from Garcia and Gorson, because in this cases there was a question if the image rights are royalties under Article 12 DTC, but it was wrongly assumed that we can make a comparison to these judgments, because when we look at the tax treaties from these cases, there is another definition of royalties, because there states in this agreement that royalties are other rights of property. And we have a conclusive list in Article 12, paragraph 3 DTC, where there is not such an annex, so one cannot make this comparison that in our case image rights are also royalties. Thank you for your attention.
Please, Gerard, unmute. I was the one muting you because there were some disturbing sounds during the meeting.
So I would like to give the floor to Team D2 for Sir rebuttal.
Thank you, Your Honors and Counsel. I will address 2 sub-rebuttal points. Firstly, the fact that we are targeting Stargolf along with not Mr. Buggy, and the second rebuttal point regarding Stargolf's incorporation. As far as how we're targeting Stargolf and Mr. Buggy, regardless of the person, whether it's Mr. Buggy, who truly received the items of income, and therefore we can use our own domestic anti-abuse laws to pierce the corporate veil and tax Mr. Buggy directly, is in play. We, the government, are also allowed under Article 17, paragraph 1, regardless if it was the corporation or Mr. Buggy himself who participated in Fairway Golf Tournament, to tax that person or entity. Now, the second sub-rebuttal point is Stargolf's incorporation. The council just mentioned the when Stargolf was incorporated, when Mr. Buggy was a resident in Championship Republic. That's when Stargolf was incorporated. But they still did not answer the why. Why was there compelling reason to incorporate in Championship Republic? This fact, along with the fact that we cannot ignore or simply turn a blind eye to the fact that Championship Republic is the jurisdiction, was the lowest tax rate, was not taken into account as the primary purpose for incorporating in Championship Republic. We also draw attention to Ms. Dotz. And it is true that other personal assistants are residents of Championship Republic, including Mr. Buggy. That's true. But look at where they are. They're in the Kingdom of Greens. All the leadership, and arguably Ms. Dotz, who's shouldering the leadership, Mr. Buggy in this case, by being the personal assistant, Mr. Buggy cannot operate without the assistance of Ms. Dotz. And therefore, the leadership of this company, The heart and brains of Star Golf is in the Kingdom of Greens, and therefore it shouldn't have been incorporated in Championship Republic. And with that, I yield my remaining time for questions.
Okay, thank you very much. Then it is time for the judges to put questions forward, and I will start to give the floor to Mrs. van der Kerken.
Thank you. I have a question for defendant team D. You state that the Star Company is abusive. However, we see that it does conclude contracts, that it keeps contacts with organizers, only six tournaments, if I read things correctly. But we could say that the purpose of the company might still be managing the career and income of this Mr. Buggy. However, not the day-to-day arrangements, as in meals and keeping the calendar. Is this really an abusive company? You also stated that its seat is not really in the state in which it was incorporated, if I read it correctly, so that has to be taken in mind also. But if you look at a question, is it really abusive? And secondly, if you look at the reasoning for incorporating it in Championship Republic would be seeking the lowest tax rate possible on profits. Could you say, and that's the second point maybe, is this a benefit meant in Article 29 of the treaty? Simply establishing the fact that the tax rate of the state in which the company is incorporated is low.
Thank you, Your Honor. Let me go ahead and address the first point in terms of determining if Star Golf is indeed abusive in its actions of incorporating in Championship Republic. Did I hear your question correctly?
Yes, that's it. Yeah.
Perfect.
That's what I meant.
We reaffirm our position and hold yes. Because if we look to where its leadership is, Mr. Buggy, who is the heart and soul and brains of Star Golf, he left Championship Republic along with his personal assistants after it was incorporated. It wasn't before, it was after it was incorporated. And it just so happens that Championship Republic is the country known to us with the lowest tax rates. So we can see that Mr. Buggy's actions are indicative that the only reason for Star Golf to be incorporated in Championship Republic was to take advantage of that lowest tax rate. And therefore, that was the sole or main purpose of that arrangement. As far as the second question, may you please repeat that?
Well, what I meant is, you say it's reasonable to conclude that what is meant here is obtaining a benefit. What is sought after here is obtaining a benefit of the treaty. But okay, you say that establishing the company in Championship Republic is abusive. I understood that correctly. But is seeking a lower tax rate meant as a benefit in Article 29? Is that a benefit of the treaty?
So there is nothing wrong with efficient tax planning. That's fine. If the world doesn't have that leniency of efficient tax planning, then we wouldn't be very economically driven, frankly. But for purposes of Article 29, we look to the reasonable standard for inappropriate situations. So we saw that the inappropriate situations was Star Golf being incorporated and Mr. Buggy leaving. So there's nothing wrong with taking into consideration efficient tax planning transactions. But when it's done in an inappropriate manner, such as in Mr. Buggy's situation, such actions cannot be honored. So Article 29 allows for efficient tax planning, not inappropriate as Mr. Buggy committed here.
give the floor, I think, to Mr. Nogueira. Oh, you have to put the microphone on.
Okay, thank you so much, and apologies for that. I'm going to focus my questions on Team E. Still on this benefit issue, you mentioned that the benefits of 2.5%, I think literally is not enough or is not sufficient for applying the clause. Why is not a benefit of 2.5% enough? Is there a material threshold, or you consider that the benefit is not the tax saving? And a question for E3. The question for E3, or I would like E3 to clarify your position on Article 12, because if I understood, Article 12 could be applicable. I would like to understand the connection between Article 12 and copyright, because this court takes the position that looking at the UN model, you need a copyrighted item to be in scope of Article 12. So could you clarify your position?
Thank you. I would like to answer your question first. So we said that a benefit of 2.5% is very, very low, and we doesn't have a double non-taxation, but it's I'm fine with it. It's still a benefit. And in our opinion, the benefit is so small and so unimportant that we can't say that the Starbucks company was incorporated for just 2.5%. One tournament out of 6 that take place per year, and in comparison, the earnings of the Starbucks company are significantly higher. For example, the 3 other golfers, the Startup company earns at least 10% from the earnings of each of them for every tournament. And if I met his friends and other professional golfers, like the tax authority told us, it's really much money, so we can tell that it's very more important than just the 2.5% that the tax authority, that the company saves through this incorporation as an accident, I would say.
Yes, thank you for your question too. I would like to clarify my position to Article 12 TTC. So we have the Article 12 from the UN Model Convention, and in the UN Model Convention we have a conclusive list in Article 12, paragraph 3 DTC, and there is defined what royalties are. So we must have something from this conclusive list. And in our understanding, we have neither trademark nor anything else that there is listed. And because we have not the annex that any right or property can be royalties, such as the United Nations cases, we cannot simply refer that image rights fall under royalties in our convention. So in our understanding, the application of Article 12 UTC is not opened.
But you had an argument. If Article 12 was applicable, I couldn't understand that subsidiary argument.
When Article 12 is applicable, then the taxation of 10% cannot be exceeded simply because.
Understood.
Okay.
Understood.
Okay. Well, I have one question for, at least one question for D2. What puzzled me a little bit is that you stated that we are in the tax jurisdiction of Waterland, and Waterland has a domestic general anti-abuse rule, and it simply can be applied. And you spoke about lifting the corporate veil, but, well, I can understand that in relation to a domestic situation, but we are here in a cross-border treaty situation. So isn't that something different? I mean, you argue as if it's just obvious that a domestic general anti-abuse rule can also be applied in a international cross-border setting, and is that so obvious?
It is that so obvious, Your Honor, because all the countries agreed upon that the domestic law of all countries provides for a general anti-avoidance rule similar to the principal purpose test, but for the initial test being that the tax benefit must be the sole or main purpose of the arrangement. So while we are in one jurisdiction, the fact that this domestic anti-abuse law is the same per country allows us to invoke it, regardless of the jurisdiction we are in.
Okay, because all countries would have a comparable general anti-abuse rule, vice versa. And therefore there is no, how do you say that, treaty override.
Can you clarify your question, please?
If I understand your reasoning, you say, well, all countries involved apply a domestic general anti-abuse rule, and therefore there is also not anything occurring as treaty override.
There would not be any treaty override because the treaty specifically under paragraph 66 of the commentaries to Article 1 allowed for the activation of the country's general anti-avoidance rule. So we're not cutting off or we're not trying to circumvent the tax treaty, but rather we're invoking the rights that the treaty gave us to begin with.
Okay. And then, well, at least one question for Team E. I think Team D argued about the concept of beneficial ownership and arguing that the Gulf company is not the beneficial owner because I presume all the profits were distributed to the shareholder, and that the shareholder is the beneficial owner, and he has the power to decide about the dividend distribution. What is your position on that? That the Gulf company is not the beneficial owner of the revenues?
Thank you for your question. The most important point on this case is that we have no contractual or legal obligation that already mentioned in my pleading. So we have no obligation as what happens to the money. So the Stargolf company becomes the entire income, and then it is not clear what happens with the money. So the Stargolf company as such can decide if they want to distribute it to its shareholders, or if they want to invest something or something like this. But because we have no contractual or legal obligation, one cannot conclude that this is sufficient to say that the Stargolf company is not the beneficial owner.
Okay. And then I look at the time. The last question for E1. You said, well, 2.5% is not very much. So no case of abuse. But you could also state, well, seen solely from the perspective of Waterland, there's a difference of 15% because there is no taxation at all. Isn't that then abusive?
Thank you for your question. I would answer that we cannot decide, no country can decide just to tax from the tax authority side. We have a tax treaty, and this has to be interpreted correctly. So in our tax treaty, the only thing that could be considered is that the company would be abusive. But like I already said, the company isn't abusive. So the Article 7, paragraph 1, Article 7, DTC assesses the right of taxation of the Championship Republic. So the Championship Republic can tax the company, and the 2.5% should, like the tax authority said to us, are assigned for the abuse. But it's not about what the tax authority would like to have for the country. It's about what the taxpayer want to say in a question of abuse. Thank you.
Yeah. Okay. thank you very much. I see that the time is up, so I thank all the participants in this moot court. It was very interesting, I think, for us as judges to hear all the pleadings and to hear all the arguments, and so we thank you for that. And yeah, that ends this pleading session, and the court will have to start grading the performances. So thank you very much, and bye-bye.
Bye.
Congratulations, bye-bye.
That's it.